In Episode 1, we built the architecture of the Information Technology Act. We saw that it is not merely a list of cyber offences. It gives legal recognition to electronic activity, regulates particular forms of digital conduct, supports cybersecurity, and assigns responsibilities within the online environment. But a legal provision cannot be applied until we know what its words include. Is a smartphone only a communication device? Or can it also form part of a computer resource? Is a message data, information, or an electronic record? When a platform carries somebody else's content, is it acting as an intermediary? And if the conduct begins outside India, what brings it within the IT Act? These are not technical preliminaries. They decide whether the Act enters a dispute at all. Welcome back to Beyond Bare Act. In this episode, we move from architecture to application, the scope of the Act, the definitions that control its operation, the transactions it expressly excludes, and its reach beyond India. Consider a simple situation. Riya is a student in Dehradun. She uses her smartphone to upload a scholarship application to a cloud service. Later, somebody outside India obtains her login credentials, enters the account without permission, and sends a fraudulent message to a recipient in India. The facts sound straightforward. The legal analysis is not. What exactly was accessed? A phone, an account, data, a computer system, or several connected resources? Is Riya the originator of the fraudulent message merely because it left her account? Is the cloud service the addressee, an intermediary, or both? Does it matter that the person responsible was outside India? And is an Indian recipient by itself enough to make the IT Act applicable? Before identifying liability, the lawyer must classify the technology, the information, the actors, the conduct, and the territorial connection. That is the method we will learn in this episode. The starting point is Section 1. The Act extends to the whole of India. Section 1 also states that, unless the Act provides otherwise, it applies to an offence or contravention committed outside India by any person. That second statement is important, but it is not a complete rule on its own. For conduct outside India, it must be read with Section 75, which supplies the necessary statutory connection. We will return to that connection shortly. Section 1 also tells us that the Act does not apply to the documents or transactions listed in the first schedule. So scope has 3 layers. First, the Act's ordinary territorial operation within India. Second, its conditional application to conduct outside India. And third, express exclusions for particular documents and transactions. Notice the discipline this creates. We do not begin by asking whether the facts feel digital. We begin with the statute's field of application. The first schedule is easy to overlook, but it prevents a common error, assuming that the IT Act supplies legal recognition to every document merely because it exists electronically. The current schedule lists 5 categories: a negotiable instrument other than a cheque, a power of attorney, a trust, a will including another testamentary disposition, and a contract for the sale or conveyance of immovable property or an interest in that property. A cheque is expressly treated differently from other negotiable instruments, and the Act contains a separate provision concerning electronic cheques and truncated cheques. What does an exclusion mean? It means that the IT Act's framework does not apply to that listed document or transaction. It does not, by itself, answer every question about whether some electronic process may be recognised under another law, a special statutory system, or the facts of a particular case. For example, a person should not argue that an electronic will is legally valid merely by pointing to Section 4 of the IT Act. The first schedule prevents that shortcut. The applicable succession law and its formal requirements must be examined. The careful conclusion is therefore limited but important. The IT Act is a major legal foundation for electronic activity, not a universal electronic substitute for every legal formality. Once the Act applies in principle, Section 2 supplies its working vocabulary. Statutory definitions are not dictionary suggestions. When the Act defines an expression, that definition normally controls unless the context requires otherwise. The easiest way to understand Section 2 is not to memorise it alphabetically, it is to arrange its important definitions into 4 families. First, objects and infrastructure, such as computer, computer system, computer network, communication device, and computer resource. Second, information and records, data, information, electronic form, and electronic record. Third, people and roles, originator, addressee, intermediary, and subscriber. And fourth, actions and security, including access, cybersecurity, and secure system. Let us use those families to classify Riya's incident. Start with the device in Riya's hand. The Act defines a communication device to include cell phones and other devices used to communicate or transmit text, video, audio, or images. A smartphone plainly performs that function. The definition of computer is broader than the everyday image of a desktop machine. It focuses on electronic, magnetic, optical, or other high-speed data processing and includes connected input, output, processing, storage, software, and communication facilities. A computer system may be a device or collection of devices containing programs, instructions, input and output data, and performing functions such as logic, storage, retrieval, communication, and control. A computer network is an interconnection of computers, computer systems, or communication devices through wired, wireless, or other communication media. The interconnection need not be continuously maintained. Then comes the umbrella expression, computer resource. It includes a computer, computer system, computer network, data, a computer database, or software. This structure matters because different sections use different expressions. A provision referring to a computer resource may reach more than a provision framed around one physical machine. It also explains why the smartphone question cannot be answered by attaching only one label. The phone is expressly a communication device. Depending on the provision and the function being analysed, it may also be part of a computer system, a network, or the wider computer resource architecture. The legal method is functional. Identify what the device was doing, then read the exact language of the applicable provision. Now classify the content. In ordinary conversation, people often use data and information as if one must exclude the other. The Act does not create such a neat binary. Data is defined around a formalised representation of information, knowledge, facts, concepts, or instructions that is intended to be processed, is being processed, or has been processed in a computer system or network. It may exist in different forms or be stored in computer memory. Information is an inclusive definition. It includes data, messages, text, images, sound, voice, codes, computer programs, software, and databases, among other listed forms. Electronic form, in relation to information, concerns information generated, sent, received, or stored using the media described by the Act, including computer memory and similar devices, and an electronic record includes data, a record, an image or sound stored, received, or sent in electronic form. These expressions overlap, but they are not pointless repetitions. Data draws attention to formalised material capable of computer processing. Information is broadly inclusive of different kinds of content. Electronic form describes the medium or mode. Electronic record gives the Act a legal object that can be generated, sent, received, stored, attributed, acknowledged, authenticated, or produced. Riya's application may therefore contain data and information, exist in electronic form, and constitute an electronic record. Which expression matters most will depend on the section being applied. A lawyer should resist the urge to select one label too early. Several statutory descriptions may operate at the same time. Next, what did the unknown person actually do? Section 2 defines access as gaining entry into, instructing, or communicating with the logical, arithmetical, or memory function resources of a computer, computer system, or computer network. That is wider than physically touching a device or merely seeing its home screen. But the definition of access does not itself prove unlawful conduct. We must still examine permission, the acts described by the relevant substantive provision, and, where criminal liability is alleged, any required mental element. In Riya's case, stolen credentials may explain how entry occurred. They do not automatically transform the intruder into an authorized user. Definition first, liability second. The actors require equal care. An originator is the person who sends, generates, stores, or transmits an electronic message, or causes it to be sent, generated, stored, or transmitted to another person. The definition excludes an intermediary. An addressee is the person whom the originator intends to receive the electronic record. Again, an intermediary is excluded. An intermediary, with respect to a particular electronic record, is a person who, on behalf of another, receives, stores, or transmits that record, or provides a service with respect to it. The definition includes categories such as telecom and internet service providers, web hosting services, search engines, online payment sites, online marketplaces, and cyber cafes. Two qualifications are essential. First, intermediary status is connected to the particular electronic record and the function being performed. A company may be an intermediary while transmitting a user's message, but an originator when publishing its own notice. Second, falling within the definition of intermediary does not automatically grant immunity. Section 79 contains a conditional safe harbour framework. Its requirements must be considered separately. Return to Riya. The fraudulent message left her account, but that fact alone does not establish that she was the person who generated or caused it to be sent. Attribution is a factual and legal question. The unknown intruder may be the relevant originator, the Indian recipient may be the addressee, and the service may act as an intermediary for that particular record. The labels follow functions and evidence, not assumptions based only on whose name appears on the screen. Section 2 also distinguishes a broad protective activity from a defined quality of a system. Cybersecurity concerns protecting information, equipment, devices, computer resources, and stored information against unauthorized access, use, disclosure, disruption, modification, or destruction. A secure system is defined through qualities such as reasonable security against unauthorized access and misuse, reasonable reliability, suitability for its intended function, and adherence to generally accepted security procedures. These definitions help us describe the environment. They do not create a guarantee that any system labelled secure can never be compromised. We can now answer the cross-border question. Section 75 states that the Act may apply to an offence or contravention committed outside India by any person, irrespective of nationality. But subsection 2 supplies the condition. The act or conduct constituting that offence or contravention must involve a computer, computer system, or computer network located in India. There are therefore at least two gates. First, identify an offence or contravention created by the IT Act. Section 75 extends the Act's application. It does not independently create a new offence. Second, identify the statutory Indian connection. The relevant conduct must involve a computer, computer system, or computer network located in India. Imagine that an intruder sitting outside India accesses a computer system located in India without permission and performs conduct covered by a substantive provision of the Act. Section 75 is designed to prevent physical location or foreign nationality from automatically placing that conduct beyond the Act. Now change the facts. Suppose an overseas disagreement merely causes financial or reputational harm to an Indian person, but no identified offence or contravention under the Act, and no required connection to a computer, computer system, or network located in India can be established. We should not treat Section 75 as a universal answer simply because the Internet was used or an Indian was affected. Cloud systems make this analysis fact-sensitive. A service may use several devices, networks, and data centres across jurisdictions. A lawyer must identify the relevant resource and location rather than using the cloud as if it were a single legal place. Finally, statutory applicability is not the same as practical enforcement. Investigation, preservation and access to evidence, cooperation between authorities, service on a foreign entity, and other procedural questions may determine whether a case can effectively proceed. Section 75 answers an important question of legal reach. It does not remove every cross-border difficulty. Let us apply the method without inventing facts. Riya's phone is expressly a communication device. The account, software, data, and connected infrastructure may engage different parts of the computer resource framework. Her application and the fraudulent message may be data, information, and electronic records at the same time. The unknown person's entry may amount to access, but liability still depends on permission, the substantive provision, and any required mental element. The apparent sender's name does not settle originator status. The intended recipient may be the addressee. The service may be an intermediary with respect to the message, although Section 79 protection would require a separate analysis. And because the suspected intruder was outside India, Section 75 requires more than the fact that Riya is Indian. We must identify the IT Act offence or contravention and the computer, system or network located in India that the relevant conduct involved. The disciplined answer is not a dramatic yes or no. It is a sequence of legally necessary questions. When you confront a new IT Act problem, use this application test. 1. What conduct actually occurred? 2. Which statutory object or resource was involved? 3. Which person performed which role for the particular electronic record? 4. Is a first schedule exclusion engaged? 5. Where did the conduct and the relevant technology operate? 6. If the conduct occurred outside India, what computer, computer system or computer network located in India did it involve? 7. Which substantive section creates the alleged offence, contravention, right or responsibility? And 8. What questions of evidence, procedure, enforcement or another applicable law remain? This method prevents definitions, jurisdiction and liability from collapsing into one vague conclusion. We now have the language needed to apply the Act with precision. Scope tells us when the statute enters the analysis. Definitions identify the technology, information and actors. The first schedule marks the boundaries of the electronic recognition framework. And Section 75 explains when an offence or contravention outside India may still fall within the Act. The next step is to ask what the Act does with an electronic record once it is inside that framework. How does electronic authentication work? When does an electronic signature receive legal recognition? Can an online exchange create a contract? And how do attribution, acknowledgement, time and place operate when a message crosses networks? Those questions form Episode 3, Electronic Records, E-Signatures and Online Contracts. This is Beyond Bare Act, Law in Context, Power in Practice.